Members, this is the appointed time and we have a quorum. So I call this meeting to order. This is the meeting of the Bills Committee on Evidence Amendment Bill 2026. So let's begin. Item 1 on the agenda. Meeting with the administration. I will invite the Secretariat to invite the administration to come in. Members, for background information, please refer to the papers set out in the agenda. First, CPA 5019/16C, the Legislative Council brief, and also LC paper number LS 34/2026, the LSD report, as well as the background brief prepared by the Secretariat, LC paper number CB-3 804/2026-05. Let me welcome the administration. We are joined by Mr. Llewellyn Mui, Solicitor General, Department of Justice, as well as Mr. Jonathan Mann, Deputy Director of Public Prosecutions, and Ms. Heidi Lee, Senior Assistant Solicitor General, Policy Affairs 2, as well as their team. Now, I've just gone through all the papers related to the agenda. Now, let me ask members whether we should seek views from the public, the relevant individuals and organizations to submit views. So, what's your view, members? Should we just invite written views or what? Do I have member support? All right, if members agree that we should invite the public to write in, the Secretariat will publish a notice on the LegCo website, and according to the established practice, the 18 district councils will be informed. All the written submissions received will be forwarded to members. They will also be forwarded to the administration for a consolidated written response. So, I've sought members' views on the above. We'll now start a discussion on the merits and the principles of the bill. Please note that the legal advisor wrote to the administration on the 30th of June 2026, and that's CB-3 804/2026-01. The administration has already provided a written response, and that's CB-3 804/2026-02. Please note the papers. So now I will invite Mr. Llewellyn Mui, Solicitor General of Department of Justice, to walk us through the bill. Members, if you want to speak, please press the Request to Speak button. Mr. Mui will take the floor now. Thank you, Chair. To facilitate members' understanding of my presentation, we have prepared a PowerPoint. So, in a moment, when I start my presentation, I hope members can refer to the slides in the PowerPoint. We'll focus on the policy considerations of the bill, as well as some key points in the new mechanism. So perhaps I'll start by explaining our major consideration in drawing up the bill, and that is there is a need for reform. And in fact, we have drawn up the statutory framework on the recommendation of the Law Reform Commission. In my coming presentation, members will see that as far as the framework is concerned, there are safeguards to help us strike a reasonable balance. I will start by explaining a technical concept. I will explain this concept, and I hope that members will be able to grasp the core concept. This bill seeks to address the issue of admissibility of evidence in criminal proceedings. So, when it comes to evidence adduced in the proceeding, we need to first consider whether the evidence is admissible. And if the evidence is admissible, and if certain statutory conditions are met, the next question to ask is how much weight should be given in considering the evidence. So step 1 is admissibility. This question is to be decided by the judge. The judge will consider whether the legal principles are met and that the evidence is admissible. If it is not admissible, it will be excluded from the proceedings. Then we come to step 2. If the evidence is admissible, and according to general legal principles, the next question is how much weight should be given in considering the evidence. In criminal proceedings, the presiding judge or magistrate in a tribunal of fact will decide on the matter. So let's say if this is a jury trial at the High Court, then it's for the jury to decide how much weight should be given to the evidence, subject to the judge's direction. If it is the proceeding at the district court or the magistrate's court, then it's for the judge or the magistrate to consider the same question. So in criminal proceedings, the crux of this bill relates to hearsay evidence and its admissibility. I will explain what hearsay evidence is. It refers to representation of fact or opinion. Made by somebody other than that person related to the legal proceedings. In other words, it's the third party that cites such representation of fact or opinion. And the purpose of tendering the evidence is to prove the truth of its content. The PowerPoint slide refers to an example. I'm not going to repeat it. I think that this is a rather straightforward example for members' reference. It explains what hearsay evidence is. At common law, hearsay evidence is inadmissible to prove the truth of its content. So this is the general principle under the common law system. But there are exceptions. There are exceptions under the legal framework. For example, the declarant cannot attend legal proceedings and the evidence cannot be cross-examined for the tribunal to consider the credibility and accuracy of the evidence. This is the common law principle generally adopted, and yet we also note the inadequacies. For example, it's rather complex. These exceptions already established under the common law are quite complex, and that this may result in the lack of flexibility. Even if what the hearsay evidence seeks to prove is indeed the truth, and even if hearsay evidence is cogent and reliable, under the current rule of the common law, hearsay evidence will still be excluded. And I want to make a point here. In relation to the rather harsh consequences stemming from the rigid hearsay rule, it often leads to some undesirable consequences that may cause prejudice to the legal proceedings. And I'd like to cite a real-life example. This happened quite recently in the district court. There was a case involving a 13-year-old boy suffering from anxiety and depression. He got acquainted with two men through a dating app. He was later sexually assaulted. The police received the report. The police also took a detailed video recorded interview from the boy. And then the boy's condition later on deteriorated. He showed suicidal tendencies. He could not attend court and be cross-examined. According to the current hearsay rule, the video recorded interview therefore could not be tendered as evidence to testify against the two defendants. As a result, one of the defendants had originally planned to plead guilty, but because of his knowledge of this boy's deterioration of mental condition, he considered that there would not be sufficient evidence to prove his guilt. And then this defendant changed his plea from guilty to not guilty. As a result, prosecution could not proceed. This is an undesirable consequence. The administration is of the view that a reform should take place as quickly as possible. In fact, in 2009, the Law Reform Commission published a report. And in 2018, the administration tabled a bill into the Council to implement the recommendations in the report. But due to lapse of time, we couldn't proceed. The Bills Committee had been set up. Deliberations had been conducted, but because of lapse of time, the proceedings could not be completed. And in fact, recently we've conducted another review, and that is the background of the bill. We hope to implement the recommendations as quickly as possible. The objective of the bill, simply put, is to reform the rather rigid and complex hearsay rule under the common law system in criminal proceedings. Under certain specified circumstances, hearsay evidence would be accepted, but of course subject to some very stringent requirements. We also put in place safeguards to strike a balance. And through this bill, we strive to reform the rigid hearsay rule so as to bring about changes. So, overall speaking, our approach is a balanced one. And from this slide, you will find that we have referred to the LRC report. The LRC considered the approaches in different major common law jurisdictions. There were different approaches, and that having carefully considered the matter, the LRC is of the view that we should adopt a model similar to that in New Zealand, which is a more balanced approach. It will not be too rigid or too loose. And in a moment, I'm going to go through the salient points in the proposed framework. And how we take this balanced approach. So, subject to passage of the bill, this will apply to some criminal proceedings. Well, and there are also specific provisions excluding the application of this bill in certain proceedings.
喺刑事法律程序入邊，佢本來係要咧根據一啲所謂嚴格證據規則去處理呢啲證據問題嘅一啲嘅刑事嘅法律程序咧，就係會適用呢個新嘅制度嘅。咁另外一方面咧，就係喺判刑嘅法律程序啦。如果係由控方去提出一啲嘅。
For the scope of application for criminal proceedings to which strict rules of evidence apply, this will be covered and applicable. For sentencing proceedings, hearsay evidence adduced by prosecution to prove disputed aggravating factor. In this situation, this will be covered as well. And also for surrender of fugitive, for committal proceedings, and also for appeals. For this kind of situation, for applicability and covered situation, it is not that all surrender of fugitive cases evidence will be covered with this new mechanism. For at present, for surrender of fugitive in Hong Kong, where the overseas party, according to their requirement, usually they would require written submissions concerning the violation itself. And let's say the fugitive had escaped to Hong Kong, let's say, then the overseas country concerned, the local country concerned overseas, according to the rules, they would only admit written submissions. So for the surrender of fugitive situations, it is only in the Hong Kong courts where the fugitive had been brought in front of the Hong Kong court. Then within Hong Kong, including the police force of Hong Kong, they will have to prove how this fugitive had been arrested and apprehended, and the requesting country will have certain requirements as to how to prove the identity of this fugitive. And in this kind of situation, the surrender of fugitive will be covered by this scope of application. But we expressly say that this will be not applied where national security proceedings are concerned. And the reason being, for this kind of cases, very often they pertain to national security, major national security considerations. And after consulting the relevant law enforcement parties and departments, and after careful consideration and assessments, we come to the conclusion that for national security related proceedings, they should continue to use the evidence rules that are most stringent. That is to say, this new mechanism will not be applicable to national security proceedings. And for this kind of proceedings, the defense or the both sides actually will not be able to use this mechanism. So according to the common law rule, it would be a more stringent proceedings or set of criteria without the flexibility. But this is to better safeguard national security, and therefore our policy proposal is to make this not applicable to national security proceedings. For sentencing proceedings, next, the defense may adduce certain hearsay evidence in an attempt to prove mitigating factor, and adduced by prosecution to prove undisputed aggravating factor, that is to say, the prosecution does not object to it, then this will be applicable. This will be within the scope of application. Actually, this is the existing arrangement as well. For sentencing proceedings, as I've mentioned just now, it is only when the prosecution wants to prove an aggravating factor and the defense objects to it, then the scope will cover that kind of situation, but not for other sentencing proceedings. Thirdly, for proceedings which had commenced before the bill's commencement, then this scope of application would not be applicable, and this is only the existing practice, because the bill has not commenced yet for proceedings that had already commenced. So, for the bill, in terms of its framework or direction, a very simple way of putting it is that if this is supported by the lecture and approved, and it has come to commencement and implementation, under what circumstances can there be criminal proceedings, hearsay evidence admissible? Well, you can look at the right-hand side of this particular slide. This is where, under this new statutory scheme, there will be a new statutory gateway with this new framework that is implemented in the future if it is to be passed. And I will be talking about a few areas under that. As for existing statutory exceptions, that is to say, where there's statutory law, there is already evidence from hearsay that is made admissible. For example, for our evidence law itself, there are certain terms that bring in the admissibility of hearsay evidence. For example, public documents, government documents, etc. For these kind of situations, there can be evidence from hearsay admitted. And also a third situation is where preserved common law exceptions. There are these exceptions, and according to the Law Reform Commission proposal, it is proposed that there are certain exceptions under common law which need to be or should be preserved. And we have accepted that proposal. And there is a list underneath where you can see what these exemptions are. Now, in the future, hearsay evidence is admissible through three specific statutory gateways. One is that where the prosecution and the defense both agree that the hearsay evidence is admissible. Another gateway is where hearsay evidence notice is filed by one party, and within the prescribed time, the other side, that is the other side, the other party to the case, raises no opposition. So this is another statutory gateway for hearsay evidence to be admitted. A third gateway is that where the party to the case, for example, the prosecution had raised the notice, but the defense objects to it, then the court will determine admissibility against stringent criteria under this particular piece of legislation to decide whether the hearsay evidence is to be admitted. So these are the three situations or gateways. Now, we go on to say where there is an agreement for admission because there is no controversy between the two parties, prosecution or defense. According to the report of the LRC, it says that there should be an opportunity to accept this situation. And according to Section 55K of the bill, it says that judicial efficiency is promoted where the parties consider the hearsay evidence uncontroversial and agree to admit it. So the advantage is that there will be increased efficiency for the judicial system. Another situation or gateway is that there is unopposed hearsay evidence notice that is raised by one party, and this is under Section 55L, where hearsay notice is given and not opposed, the hearsay evidence is admitted, and that is, this has to be done within a fixed period of time if there should be any opposition. A third gateway is where there is opposition, and in this kind of scenario, the court will make a decision. According to the bill right now, we have a description for this kind of situation. Compared to the 2018 version, there is improvement in the content of this. And later on, we can go through the details as to how we have made enhancement from the original draft. And also there are notifications, and the court has broader discretion concerning the proceedings. And for the bill, as it stands now, there are certain circumstances where there can be oral notice given right before the court for certain contingency or unexpected situations, where the court has discretion to accept or not accept the hearsay evidence. There are certain guidelines under 55R. Under 55R, there are 5 statutory criteria mentioned. First of all, the maker of the hearsay statement, that is the declarant, is sufficiently identified. A second criterion is that the hearsay statement would be admissible if given as oral evidence in the proceedings itself. So what it means is that, simply put, at present, according to criminal proceedings where there is a witness providing a statement in court, there are certain statutory requirements. For example, whether he is a qualified and competent witness, or the evidence to be raised by this witness because of certain statutory requirements, he had contravened certain limitations. For example, professional privileges, etc., and I'm sure you know very well about that. These restrictions under this situation need to be considered as well. Even though we say that the witness, the declarant, cannot come to the court in person, but will have to raise the evidence through hearsay evidence. But on the other hand, if the declarant can be appearing in court but does not satisfy those requirements as mentioned just now, then this criterion 2 would kick in reasonably. So if these two criteria, that is criteria 1 and 2, are satisfied, then criteria 3, 4, 5 are important criteria. For example, the condition of necessity, whether it is fulfilled. Later on, I will be describing in detail what comes under this necessity requirement. And also, condition 4 would be threshold reliability. Now, with the satisfaction of the 4 criteria, then the value of probation, that is to say, in the case having to prove certain facts or issues, how valuable it is, that constitutes probative value. And the probative value of the hearsay evidence has to be greater than any prejudicial effect. And one will have to balance the situation concerning the declarant.
If all these conditions are met, the court will then consider granting permission for the applicant to deduce hearsay evidence. I'd like to elaborate on the necessity condition for members' benefit. There are 5 criteria regarding the necessity condition. The first one is that the declarant is dead, so that's straightforward. The second factor is that the declarant is unfit to testify in person or in another competent manner by reason of age, physical or mental condition. Third, the declarant is outside Hong Kong. For example, this declarant is in another country, and it is not reasonably practicable to secure his attendance or make him available for examination in another competent manner, for example, through televised link. That means he cannot be arranged in a reasonably practical manner to be made available for examination. Fourth, despite all reasonable steps taken, the declarant still cannot be found. So, comparing to the third criterion, the fourth criterion is that this declarant may or may not be outside Hong Kong. The court must be satisfied that all reasonable steps have been taken and the declarant cannot be located. Fifth, if the declarant testifies, then he may be incriminating himself, and that's refusing to testify on self-incriminating grounds. But only the defense may apply for this refusal. And let me explain. In 2018, when we tabled the Evidence Amendment Bill in the Council, some members then expressed the following view, and that is, according to the LRC's recommendation, either the prosecution or the defense could cite this ground. In 2018, members deliberated and considered that most likely it would be for the prosecution to cite this ground. And if the prosecution witness refuses to testify on grounds of self-incrimination, then the prosecution may make an application to adduce the hearsay evidence instead, and that may prejudice the interests of the defense. The government considered this view. We believe the existing approach to be more appropriate because if deemed fit according to the facts of the case, an alternative approach can be taken. That is, if somebody refuses to testify on behalf of the prosecution on self-incriminating grounds, then the prosecution may offer immunity. That is, this witness may be immune from possible prosecution. We see eye to eye with the members offering that view at the time. So that is why, for the fifth criterion, we now agree that it should only be applied to the defense. On reliability threshold, and that is the threshold reliability condition. Basically, we maintained the same approach as per the 2018 Amendment Bill, without amendment. That is, it is based on the LRC's recommendation. Simply put, apart from meeting the necessity condition, there must be there must be evidence for the court to be satisfied that the circumstances provide a reasonable assurance that the hearsay evidence is reliable. We've listed 5 mandatory factors here. That means these are the factors the court must consider. As the declarant making the statement is unable to attend court, the court must consider the following factors: the nature and content of the statement, the circumstances in which the statement was made, circumstances relating to truthfulness of the declarant, circumstances relating to accuracy of the declarant's observation, as well as whether the statement is supported or contradicted by other admissible evidence. Simply put, the court should consider these apparent factors when considering whether there is reasonable assurance that the evidence is reliable. The declarant is unable to attend court in person, but having considered these 5 mandatory factors, the court is satisfied with reasonable assurance that the hearsay evidence is reliable. So this is a very important condition. I went through these 5 points, and even if all the conditions are met and the court has granted permission to accept hearsay evidence as admissible evidence, the bill provides robust safeguards on 2 fronts. First, the court has found hearsay evidence to be admissible based on the conditions set out. The declarant is unable to attend court in person. According to this bill, which is based on the LRC's recommendation, there are specific provisions for evidence related to the declarant's credibility to be adduced for court's consideration. And the defense, the party can make submission to the court about inconsistencies in the testimony of the declarant. And this is very important. Under this framework, the court acts as the gatekeeper. At the final stage, the court is empowered to grant subsequent exclusion. Let's say, according to the design, the court may admit hearsay evidence and the criminal proceedings would go on. But then, after admitting the evidence, the opposing party can still invite the court to consider otherwise. That is, as the proceeding goes on, and that the court has actually heard evidence from both sides, the prosecution and the defense, which means the defense may elect to give evidence, and the court would consider the evidence as well. And even at that stage, according to the bill's design, an application can be made to the court to consider all matters, and that in all circumstances, the hearsay evidence should be subsequently excluded in the interest of justice. We believe this is a very important safeguard for the court to act as the final gatekeeper. And let me explain how we have refined the ultimate safeguard comparing to the 2018 bill. So do allow me to spend a few minutes on this, as this is very important. On this occasion, we want to give courts more flexibility. If the court considers that it is in the interest of justice to do so, and that is to exclude the admitted hearsay evidence, at that stage, the court may adopt a flexible range of remedies without concluding the trial. And that is the last box at the lower right-hand corner of the table. And that is, the court may choose to continue with the trial, of course having considered the matter of fairness to both parties. Or, if the court is not satisfied that the defendant will be treated fairly, then the court may order the trial to end, and the court may also order a further trial or retrial. And lastly, if the hearsay evidence is excluded, the court may consider the remaining evidence available, and if there is insufficient evidence, the court may acquit the defendant. Now, I want to highlight this point to members because it's an improvement comparing to the 2018 model. The provisions in the 2018 bill only spelled out one solution. If we take a look at the left-hand column, if according to the court, it would be unsafe to convict the defendant on the basis of the admitted hearsay evidence, then the only avenue available to the judge is to acquit the defendant. Now, we want to capture more circumstances and allow the court more options. Very often we rely on judges in courts to make judicial judgment on the most appropriate way of handling the case. About this ultimate safeguard called subsequent exclusion, the court will be required to consider 6 factors, including the nature of proceedings, the nature of the statement, the probative value of hearsay. Basically, I'm referring to the prosecution's case, the probative value of the hearsay evidence. Now, of course, it applies to the defense as well. If this is raised by the defense, we need to consider the probative value of hearsay for the defense case. Another factor is material change in circumstances. When we come to the clause-by-clause scrutiny, I will elaborate on this. Material changes include the following. That is, material changes in relation to some of the conditions that the court should consider before admitting hearsay evidence. There may be changes that happen at a later stage. For example, despite all reasonable steps taken, the defendant cannot be located, and yet subsequently this defendant is located. Then that is a material change. We have adopted this refined approach compared to the 2018 bill, which does not address this circumstance. The court should also consider the importance of hearsay evidence to or against the defendant's case. Either party may apply for the hearsay evidence to be adduced. Finally, the court should take into account the totality of other evidence. This is exactly what I mean by ultimate safeguard. As the criminal proceeding progresses, the majority of evidence, or at least the important parts of the evidence, would have been adduced. So at that point, the court should consider the totality of other evidence in whether by accepting hearsay evidence it would be prejudicial to the defendant. We've taken on board all the views received, including those received in deliberating on the 2018 bill, as well as the views recently received, and that at that stage there should be express provisions on, for example, the fact that the defendant is unable to cross-examine the declarant of the hearsay evidence, and we fully agree that this should be something the court should consider. It's only reasonable to do so, and that is why we want to put in an express provision for the court to consider this situation, because the defendant is unable to cross-examine in court the declarant of the statement, whether this will lead to any prejudicial effect on the defendant.
So let me talk about the import of that, and then after that, where members find it necessary, we can go into further details explaining. Because this has to be in tandem with the development of the case concerning other evidence. For example, as I've mentioned just now, if there is a lot of other evidence and the hearsay evidence is not of significant importance, then this will be different. And in this case, for example, there are different possibilities as to whether the witness can be cross-examined or not. Well, under such circumstances, there can be differences in handling. And we have also collected different opinions. And at this point, it is in the bill, we say that the court will have to consider this particular factor as one of the 6 mandatory factors. And here I have a diagram concerning the last gatekeeping power of the court. Now, if the court decides that the hearsay evidence is to be excluded, how can the court handle the evidence after that? Now, if the hearsay evidence is excluded, the court will have to consider whether the defendant have to continue being cross-examined. Perhaps the cross-examination stage had not been reached yet. Then the judge will have to consider whether the trial should consider. Let's say if the court comes to the conclusion that there should be continuation of the trial, then the judge should give appropriate directions and guidance to the jury, where there is a jury. And the jury will be directed to not consider the hearsay evidence because it's been excluded. And as mentioned just now by me, let's say the prosecution's evidence is already weak, then the court might have to basically cease the trial, and the jury will have to be disbanded. So that is a decision that is to be taken by the court. So there is this particular measure that can be taken by the court according to the situation of the trial at the time. So in terms of policy for the hearsay evidence and also some of the improvements from the previous bill, I hope I have given you a clear picture through my explanation just now. Perhaps I should pause here to see whether there are any questions, policy or otherwise, from the members so that I can answer them more fully. Well, the Commissioner had used 45 minutes to go through the PPT with us, giving us the details concerning the Evidence Amendment Bill and some of the policy considerations. And here I would open this to Q&A for members. There are 4 members who have indicated they want to ask questions. I will allow 5 minutes for question and answer, and we will end this meeting at 4:45 today. And they are Nick Chan, Wu Yinpeng, Alex Fan, and Maggie Chan. You have indicated you want to ask questions. Nick Chan, please. Thank you. Now, after the amendment, if there is a case where it is completely substantiated on hearsay evidence for conviction, let's say. Now, slide 16. In that slide, you mentioned that after reasonable steps taken, the witness cannot be found or the declarant cannot be found. And in the end, there was a conviction and there was an appeal. And let's say not within 14 days, but one fine day, the declarant appears and it can be found. Does that jeopardize justice? Then the appeal hearing, should it be considered fresh evidence, or how else can it be handled? That's a first question. A second question is as follows. Now, in terms of broad directions, the question is, again on slide 16, it says reasonably practicable. But there is no details in defining reasonably practicable. So perhaps there can be further information as to how the court should consider this reasonable practicability rather. All right. If we have time, I would want to refer to 32, page 30, paragraph 32 of the bill concerning this new system, how it would affect the resources of the courts, trial durations or time, etc. Is there any impact? Those are my questions for now. Yes, the Commissioner, please. Thank you, Chair. Thank you, the Honourable Mr. Chan, for the questions. First of all, I will answer the questions 2 and 3. For the first question, it pertains to criminal procedures and prosecution process possibilities. I will invite a colleague of mine, Commissioner Mann, to answer that question of yours, the first question. So for this first question of Mr. Chan's, I would like to respond to it briefly, even though I very much understand that this question is about the future. That is, under those circumstances, it seems that the hearsay evidence is the main basis for conviction. So Mr. Chan's point is, during the proceedings, the court may find the hearsay evidence admissible, first of all, and possibly, even though during my description just now I said that there are certain ultimate gatekeeping powers, but Mr. Chan is describing a situation whereby even with this mechanism, the court may finally find that the hearsay evidence can be based on to decide on conviction, and after that there may be an appeal procedure. Concerning this question, my colleague will respond to that question from a criminal proceedings basis. But on policy consideration, let me just briefly respond to that question. We have carefully considered this particular scenario as described by Mr. Chan, even though we cannot say categorically that it would not happen. And also, just now I have used a considerable period of time with patience from members and the chair to explain the design of the amendment bill, and in particular, the ultimate gatekeeping power or authority of the court. And we want to, within the interest of justice, to be able to handle the situation as described by Mr. Chan, even though we cannot comment on the probability of such cases arising. It is possible that such cases can arise, and exactly we have therefore designed this final mechanism, which is a gatekeeping mechanism. And according to my explanation to members concerning the design just now, the defendant at that particular stage can still raise to the court to exclude the hearsay evidence. In particular, if the hearsay evidence is prejudicial to the defendant. So in Mr. Chan's case, it would be a case where the hearsay evidence is the main basis for conviction, and the prosecution would be relying on that hearsay evidence, and I'm sure the defense would grasp that opportunity to apply to the court for exclusion of the hearsay evidence. Now, if you notice, there are 6 mandatory factors that the court will have to look into, and I in particular spend time on the 6th one, and we make it very clear in our stipulation that the court will have to consider the situation where such cases arise, where the defense cannot conduct cross-examination. And in these cases, the court will have to make a decision. And basically, the prosecution is mainly relying on the hearsay evidence as basis for the prosecution. So in the future, there will have to be very careful consideration. And according to Mr. Chan's description, for such cases, if the court comes to the conclusion that there is sufficient evidence to decide whether there is a conviction or not, then of course there would be appeal mechanisms. And how would this be handled? Later on, my colleague will supplement on that.
陳議員其他嘅問題啦。第二個問題咧就係關。
Well, I will now turn to the next question, and that is on page 16 of the PowerPoint presentation. I understand Mr. Chan's concern is on point 3, not reasonably practicable. That is, the declarant is not in Hong Kong, and it is not reasonably practicable to secure his attendance or make him available for examination in another competent manner. What is meant by reasonably practicable? Let me say this. We've carefully considered the LRC's recommendation. We've decided to adopt this recommendation because condition 3 is an objective one. Now, here it says the declarant is outside Hong Kong. So it is something objective. It is not the case that the declarant finds it inconvenient to fly back to Hong Kong. This declarant may be somewhere and that using the live television or televised link to give evidence may not be an option. So it's not that case, it's an objective criterion. And according to the bill's design, the threshold is very high. It's for the prosecution to prove beyond reasonable doubt that it is not reasonably practicable to have the declarant flown back to Hong Kong or give evidence through a televised link, or for some reason this is not reasonably practicable to do so. We've carefully considered the case laws in other jurisdictions, in particular those in New Zealand and in England, and they also adopt this objective criterion. It's not as simple as the declarant being reluctant because it's inconvenient, and usually it's the prosecution which is the applicant, and the prosecution has exercised due diligence to secure such an arrangement in vain. So we do believe that it's not a straightforward case. Now, to answer the third question of Mr. Chan, according to the logical brief, after the bill has been passed, when it comes to expenses incurred because of this new mechanism taking effect, in particular additional expenditure for the judiciary, we will closely monitor the situation, and if necessary, we will talk to the judiciary. We'll conduct a review, especially if the judiciary believes it is necessary to be provided with additional resources, then we'll definitely address the matter under the established mechanism. In the initial period, we will observe very closely the cases involved and the need for resources under the new mechanism. I will give the floor to Mr. Mann to supplement. To answer Mr. Chan's question, new circumstances of new evidence may emerge during the appeal. For example, at a trial, the declarant cannot be identified, or the declarant is dead or unfit to testify, but things have changed. Well, such as, for example, this boy has mental issues which makes him unfit to be a witness. Now, it's not as rigid when it comes to the appeal stage. We need to consider the facts involved in each and every case. One important consideration is this. We need to consider what part the hearsay evidence plays at the appeal stage. Say, for example, at the trial, the conviction is secured solely based on the hearsay evidence. Now, at the appeal stage, without the hearsay evidence, will the same result be given? We need to consider factors. That is, say, if the hearsay evidence is not the material evidence but only a circumstantial evidence, or relatively speaking not as important as, say, a live witness testimony. So, at the appeal, the appellant court will consider the weight and importance of the hearsay evidence. The appellant court will need to make this judgment. And if what I just cited is true, then the argument may not stand water. So we need to consider the, each and every case. Importance and weight of hearsay evidence, they should be considered. In fact, under the Criminal Procedures Ordinance, there are express provisions on the conditions that must be fulfilled, say, at the trial. It is not reasonably practicable for the party concerned to secure this evidence. That's one matter. Another matter is whether you have exercised due diligence, and this is something that the court should consider. It's for the appellant judge to consider. If we take a broad brush approach now and suggest across the board whether it can or cannot apply, then it's really hard to give a specific answer. We need to consider the circumstances of each case. Right, wait for the second round. You'll be given a chance to speak again, Mr. Chen. I understand that the administration has explained, as per point 1, that safeguards are provided in this design. As for the second point, the administration's response is that this addresses objectively the refusal to give evidence, and not the refusal of giving evidence, but just impossibility of giving evidence. Next, Mr. Wu Yingpang. Now, the common law hearsay rule has all along been criticized as overly harsh and rigid. Cogent and reliable hearsay evidence is excluded, and this may cause prejudice. A reform is needed. This is the original intent. My question is whether sufficient flexibility will be given in the bill for the court to accept hearsay evidence on the grounds of reliability and necessity. I'm concerned about 55R. according to the Department of Justice, under Section 55R, 5 conditions should be met. And these are broad conditions that come with specific details. For example, for necessity condition and the threshold reliability condition, they come with their own factors. So altogether, there will be some dozen or 20 factors to be considered. And this is something that the contesting parties will definitely fight over. The core principle of the common law is for the witness to be put on the stand and be cross-examined in order to test his credibility. But if the court is to consider the whole basket of factors before deciding whether the hearsay evidence can be admitted, then wouldn't it be overly harsh, because not much hearsay evidence could meet all the conditions, so that in reality, again, even for cogent and reliable hearsay evidence, it will be excluded, and this will go against the objective of our reform administration. Thank you, Mr. Wu, for your questions. I fully appreciate Mr. Wu's concern. But as I said in my introduction, in relation to the general consideration, we have adopted the LRC's recommendations in drawing up this new statutory framework to handle hearsay evidence in criminal proceedings. We take a balanced approach. The LRC drew up a report with recommendations for the government's consideration. This is in fact the second exercise. We tabled the bill in 2018 to amend the evidence ordinance, to no avail because of the lack of time, and this is the second exercise. I want to explain to members that we have scrutinized and considered every detail in the LRC's report, including what Mr. Wu just referred to. In the beginning of my PowerPoint presentation, I referred to the several models that we had considered. The UK model, for example, is more lax than the one we propose now. And let me explain that. In terms of admissibility of hearsay evidence, the English model has put in place a provision to provide broad residual discretion to the court under the necessity condition, and that is, if the court is satisfied that it is in the interest of justice to do so, then the court may admit hearsay evidence. Now, Mr. Wu asked this question that relates to English model, and that for the English model, it does not come with the threshold reliability condition. In other words, you need to consider the objective reliability of hearsay evidence. The declarant is unable to attend court, and the court is in the know of the circumstances of the hearsay evidence and considers that to be reliable, and that will suffice under the English model. There is no need to consider the other aspect, and that is the threshold reliability condition. The LRC is of the view that the English model tends to be too lax and that there may be different possibilities arising from this model. In other words, hearsay evidence that are not as credible may be adduced as a result. It's a balance of power. In the English model, the court is provided with residual power to exclude hearsay evidence. Our design is not the same as the English model. We have thoroughly considered the LRC's recommendations. The LRC considered the different approaches. In the beginning, we followed the established criminal procedures ordinance, and we therefore believe we should take a more robust approach. So we're more inclined to follow the New Zealand model.
So we look at 55R. It goes on to prescribe 55S, 55T, and basically English model does not require the reliability rule. And 55S and 55T, actually, they expand basically on the necessity rule and also the gateway or the threshold reliability condition. And we basically understand that those 5 items will have to be satisfied under the necessity condition. So it's the, any one of those conditions will need to be satisfied. So this is a relatively suitable approach and a balanced approach. We believe Hong Kong should be careful in adopting a model that is suitable, and also in our reform, we should be careful to adopt such a model. And in the future, as mentioned, we will continue to refer to the reforms of major jurisdictions around the world so that we will have further information for reference. For example, for major jurisdictions, they may have certain useful cases which we believe is of value for our reference. We will continue to monitor and study them. But right now, this is the procedure that we are proposing, which we believe is right. And I understand that members would know, and also I hope you agree, that this is extremely important and of great import for evidence law as practiced in Hong Kong. And we have referred to and studied the 2018 bill and the discussions at the then LegCo concerning the bill. Well, overall speaking, there was support, but at the same time, the LegCo discussion at the time mentioned that we be cautious and go step by step, and also to have a very careful review and assessment of the situation after implementation. So we are fully on board on the concern raised by Mr. Wu just now, but we believe that what we propose right now for the Hong Kong model is a suitable one. Next, Alex Fan. Thank you, Chair. First of all, I am in support of the principle and direction of the amendment bill, and I would want to thank the administration in providing us with a very clear table, the DOJ providing us that table concerning our question raised in the last meeting. And the procedures are carefully described therein, and I have looked at it. But there are a lot more details for this particular bill, and I look forward to the clause-by-clause scrutiny process. Now, I have a couple of questions. First of all, when we look at the different jurisdictions and some of the considerations in their legislation process, and I'm looking at the document. And in Australia, there is a summary saying that in 1995, there was a federal law reform, and it says that the LRC had not expressed any views concerning this Australian model. And in the third column, it says that the DOJ said that there had been certain amendments. My question is, for this Australian model, how is it different from the New Zealand model that we seem to be adopting now? Are there major differences, even though the LRC does not mention that? But I'm sure the DOJ, in making the proposal, had definitely considered the Australian model. I'm sure there are a lot of details. If you don't have all the details here, we can discuss at the next meeting. And another question is about the Singaporean model. The list does not include the Singaporean model. I did a cursory research, and I find that Singapore had made the relevant amendment. So in making this draft for the evidence amendment bill, have you taken into consideration the Singaporean model? It's not in the list. The LRC had mentioned something in passing, and that is computer records, etc. But we are now addressing the hearsay evidence. Now, a third question pertains to Canada. It is particular, and in the list I notice that there is no amendment by a written law. Have you considered the Canadian model? In the 1980s, as far as I know, on evidence law, they have made certain amendments, but they have not gone down the route of statutory law. Now, in the end, we seem to be adopting the New Zealand model here in Hong Kong. Have you also in detail looked at the Canadian experience, why they have opted to use case law as and decision by the court? Going back to their step one, why did they make that decision? Have we looked at their experience? So have we looked at the Singaporean and Canadian model and to inform our proposal? And another question concerns when we can admit hearsay evidence. There are three scenarios. First of all, through agreement of the two parties. Secondly, through filing of notice and there is no opposition. Thirdly, the court will have to approve. I'm more concerned about the first two scenarios. Let's say if the person is not represented by an advocate or lawyer, and he gives evidence in person in the court, what are the protections for him? For example, for the agreement situation, I believe that would be much like the 61C, and that is under the criminal proceedings law. So that if there is a defendant appearing in person, whether he has to sign the admitted fact, that is not so much of a concern, but rather where there is a notice for hearsay evidence from the prosecution. Is there any guidance or concerning the legal right of the defendant in exercising the safeguard for the defendant under such circumstance? I notice section 55O, there is certain details, and then in 55P, for the court, under certain circumstances, they can change the delivery of notice, the period for delivery of notice, etc. Now, if there can be certain situations, for example, contingencies, whereby there can be just oral notice given before the court, would it jeopardize the right of the defendant? So that's my concern. Now, for this reform, there is a lot of complexities and also factors we need to balance. So I would want members to use your allotted time to the full. Well, thank you, Chair. Thank you, Professor Fan, for the two sets of questions. For the first set of questions, it is about whether we have referred to the Australian, Singaporean, and Canadian experience and models for hearsay evidence. At the present stage, my reply to members is as follows. For the documents that we have already provided to members, and just now Professor Fan had talked about one such document. At present, we provide a rather simple description in the document. Now, for the Australian and the Canadian experience and model, it seems that the way they handle this is more resemble, and in particular for Australia, let me just correct myself, for Australia, for the relevant law concerned, they have an approach of codifying the law. And if you refer to page 4 of the list describing the Australian model, my colleagues and I can go back and find out more information about it. Where we have that further information in our next meeting, we can provide that. Now, for Australia, even though it is a codification, but in fact, the regulations are not really just transferring from the common law and codifying it. No, there are certain other regulations. So for this particular approach, according to my understanding in the LRC report, there is already consideration concerning other jurisdictions. And I remember in the report, the USA was mentioned, and the US model is more like the codification model. So perhaps the members would allow us the time, myself and the team, to do some more research to see whether Australia also adopts this codification model or not. So in reply to this question, again, the LRC had considered jurisdictions using the codification approach, and in the end it is found to be wanting. And at the time, the consideration was mainly for the point that using codification approach in the Hong Kong context, it would be like for common law evidence regulations, we codify it into statutory law. But on the other hand, for these common law, where it is not ideal, where it is too complex, or where it is wanting, insufficient, and as I have mentioned just now, it is wanting because it is too complex and it is inflexible, that is too rigid and too arbitrary. And if we just codify it as statutes, it would be not satisfactory. So, yes, there are certain jurisdictions which basically codify the practice to statutes, but there were certain changes or reforms as well. It is highly probable that that is the case, and we have to go back and see whether Australia is one such example. So it is not direct transcribing into statute from common law. So, and also preliminarily for the Singaporean experience, we know that Singapore does not have a regulation to address this situation overall. As for Canada, Professor Fan is correct in pointing out that for the Canadian experience,
維持翻佢哋
Now, for the Canadian experience, you will find in page 5 of the paper that we explain that there doesn't seem to be a single statute handling this matter. So, as members know, apart from Quebec, Canada basically adopts the common law system as well. Quebec practices continental system, but otherwise it's common law for Canada, and there is no codified law on hearsay in Canada. Perhaps the LRC was of the view that Canada is not a proper reference for us. So as for other questions, I hope that members will give us time to look up and consider the different jurisdictions, Singapore as well as Australia. Now, I also like to respond to the second question, and let me briefly respond to them. In terms of adducing hearsay evidence by agreement and an unopposed hearsay evidence, what should we do to safeguard the interests of unrepresented litigants? Let me address the first scenario. By agreement, I suppose when we come to the clause-by-clause scrutiny stage, members will have a clearer idea of the exact provisions. Because if it's done by agreement, we're talking about agreement in writing. If it's an oral agreement, it must be done before the court. Now, under 65C of Criminal Procedures Ordinance, there is a mechanism for agreed facts to be introduced. We've made reference to this mechanism, and that means oral agreement is possible, but it must be done in the presence of the court, because if the matter is agreed before the court will have oversight of the matter. For an unrepresented defendant mounting a defense for himself, if there's concern that the defendant is not well versed about the content to which he has agreed, we believe the court will be the gatekeeper. Now, the second point is this. Under this mechanism of adducing hearsay evidence by agreement, there is an avenue for this agreement to be revoked or withdrawn. Initially, the defendant may have agreed, and then eventually the defendant may then consider the implications and then decides to apply for withdrawal, and this avenue is available. Another situation is this. The prosecution gives notice for hearsay evidence to be adduced. At first, the defense does not object to it. So the hearsay evidence is adduced. And then, in fact, Mr. Fan has accurately described the design of the provisions, and we have fine-tuned the approach comparing to the 2018 proposal. That is, the court is given powers to handle certain matters. At first, the party has the right to give notice, and then, even if the notice is given or the opposition notice is given out of time, you can still make this application. But I take it that members ask this question about the prosecution making an application to the court out of time in order to give notice for the hearsay evidence to be adduced. Now, this scenario is possible. But then if the defendant is not represented, will it cause prejudice? Because the defendant may not fully understand the implications. I must say that this design will not casually allow the notice to adduce hearsay evidence to be given casually. Some conditions will have to be met first. That is, whether by doing so it will be prejudicial to the defendant. The court will have to consider very carefully whether this application made out of time should be considered. And we're talking about giving notice for the hearsay evidence to be adduced and giving notice to objecting the hearsay evidence introduction. So the court is given power to oversee the procedures, and that the court must consider due process. So that is the design of this system. I hope I have answered Mr. Fan's question. I'll be happy to supplement. Right, thank you, SG, for the very detailed answer. In fact, for the first set of questions, after the March meeting of the HALS panel, the Department of Justice provided a supplementary paper. And in fact, to respond to the first set of questions, the SG already said that they would go back and consider the models adopted by other common law jurisdictions in the admissibility of hearsay evidence. So do go back and check. The second question is about the gatekeeping role of the court, but I think we can have this discussion again when we reach the clause-by-clause stage. Next, Dr. Junius Ho. Mr. Moy, I'd like to turn to page 16 about section of the slide. That's section 55R. This slide refers to 5 conditions. for hearsay evidence to be admissible. So, apart from these 5 conditions, there is still a threshold. You must meet this threshold before adducing hearsay evidence. So, who sets the threshold? Is it the court or is it the jury? Of course, if it's a matter of law, then it should be decided by the judge. If it's a matter of fact, it should be decided by the jury. And then PowerPoint page 17, nature and content of statement, circumstances in which a statement was made, and circumstances relating to truthfulness of the declarant. It seems that it falls within the ambit of Section 55R or 55T, right? By virtue of, and this is how it's drafted, that means it comes under 55T and is for the judge to decide on the truthfulness of the declarant and the circumstances relating to that. So for this bit is for the judge to decide, and it's a highly technical matter. SG? Thank you, SG. Thank you, Chairman. Thank you, Dr. Ho. I take it that there are 2 questions. Let me take the latter one. Dr. Ho's observation is entirely correct. You mentioned the threshold reliability condition. That's in fact on page 17 of the slide. Your concern is about the truthfulness of the declarant. Under Section 55T, the court is invited to consider the threshold reliability condition. This is a point of law, so Dr. Ho's observation is correct. Truthfulness is a matter of law to be decided by the court. About your first question, the 5 necessity conditions in page 16, again, Dr. Ho's observation is correct. It's a matter of fact, in fact. We have not yet reached the clause-by-clause scrutiny stage, but I suppose members already read through the bill. As I explained, the necessity condition relates to determination of facts. The LRC proposes different thresholds for the prosecution and the defense because it relates to the determination of facts. Say if the prosecution wishes to adduce hearsay evidence based on one of the necessity conditions, say the declarant is dead as per point 1 here, then the prosecution will have the onus of proof of hearsay evidence, and that the standard of proof is that adopted in a criminal proceeding, and that is to prove beyond reasonable doubt. Now, if the application comes from the defense side, then the standard of proof is on the balance of probability, and that is usually the standard of proof in a civil case for the defense. The threshold is lower. So Dr. Ho's understanding is entirely correct. The necessity condition involves determination of fact. The LRC has considered the matter very carefully. So for the prosecution and the defense, the different standards of proof apply. and it's easy to differentiate between the prosecution and the defense. I will have some other questions to ask.
Holden Chow next. Thank you, Chair. Because I have a few meetings concurrent today. If somebody had already asked this question, please excuse me. I'm looking at the document, paragraph 55R. It says that where there is objection for the hearsay evidence, the hearsay evidence can still be admissible. But there are certain conditions. For example, the declarant is already dead, that being one of the necessity conditions. 2, unfit to testify. C, is outside of Hong Kong. D, cannot be found despite all reasonable steps. And I'll stop here. For declaration of interest, I run a law firm and I handle criminal cases as well. I have a question here. Now, the reason why we are discussing hearsay evidence amendment bill and the LRC is so careful in its approach and it's gone through such a long time of discussion, we all understand this. This is for professionals. We all know this is not a paper trial because for criminal cases, we have been taught since young as lawyers, the relevant persons had better appear in court. But now the LRC is considering different situations and special conditions. And so there is this hearsay evidence bill introduced, and we understand that times have changed now. And I can understand the declarant being dead or unfit, and in the past it's happened because of reason of age, physical, mental condition, etc. But on the other hand, what about this condition of being outside of Hong Kong? The declarant being outside of Hong Kong can be for many different reasons. When my senior taught me where there is a notice served, then the declarant will have to come back to Hong Kong, summons back to Hong Kong. When summons back to Hong Kong, the declarant will have to appear in Hong Kong. There can be certain delays, maybe it's 3 months, but still within 6 months, for example, whatever time, the person will have to come back to Hong Kong. So where do you draw the line for reasonable practicability? You know, after what time do you say that the declarant is outside of Hong Kong? It is not possible to secure his attendance, right? So it's not like he provides a testimonial and in front of the police, but then leaves Hong Kong right away. Then if that is the case and he is therefore excused, then it will all be paper trials from here on. Now, if I'm repeating a question somebody had asked, excuse me, because there are concurrent meetings for me. Yes, there had been a question, a similar question asked, but I will ask the administration to answer the questions. Thank you, Mr. Chow, for the question. It is very important a question, and we agree to your concern. So, simply put, in your professional experience and from your professional perspective, we fully understand why you're asking this question, and it seems so straightforward to exclude hearsay evidence in criminal proceedings. But why are we introducing it? Well, it provides us with this question of yours, Mr. Chow, the opportunity for us to explain yet again that there are a lot of a number of different points and stages to this amendment. And Mr. Chow said that he's concerned about Condition 3 and Condition 4, where the declarant says that he's outside of Hong Kong. It's not convenient even for him to come back to Hong Kong. And for Condition 4, the witness, the prosecution witness cannot be found, and therefore his hearsay evidence can be admitted. Well, it doesn't work that way. This necessity condition is just the first step. And the possibility of each of these 5 necessity conditions, and in particular condition number 3 and condition number 4, it is not lightly established. For 3 and 4, these 2 conditions, let me explain them further. The requirement is objectivity, and the simplest concept one can apply is that one can objectively prove that all necessary steps have been taken, all efforts have been made, and this, I'm talking about condition 3 here, the overseas declarant or witness cannot be secured of his attendance to make him available for examination in another competent manner or secure his attendance. So this is not practicable under reasonable circumstance. That is condition 3. So this declarant who's outside of Hong Kong, if he just says he's not coming back to Hong Kong, that will not satisfy this condition. Or the declarant says, this is not convenient for me because I have to go to a far-off place. I have to take transport in order to get to a televised system to give evidence, and it's too inconvenient for me. I will not do it. I will not participate. That will not satisfy the condition either. And I'm explaining to members that that is the case because the RC and the consideration is very clear. In considering these conditions, it is under the objectivity test that the declarants who are outside of Hong Kong cannot reasonably, take the airplane and fly back to Hong Kong or give televised evidence. These are reasonable and reasonable means of giving evidence. Now, Mr. Chow had also asked the question and whether we have referred to relevant case laws and also referred to overseas jurisdictions experience. Yes, we have looked at New Zealand case law and also the England model, even though we said that it is not applicable for the English model, but there are certain relevance. For example, from what we have found in terms of information and response in particular to the legal advisor, we have provided 2 lists. The second list introduces briefly these case laws. So for conditions 3 and 4, we do see certain case precedents in these jurisdictions where there are situations that are, as mentioned by Mr. Chow, some very straightforward situations where the declarant is the declarant's attendance is not secured or is unavailable for examination. It's not admissible by the court. It will not be accepted by the court. But there are instances where the court would accept this. I remember a precedent in the England law where a witness was in the U.S. and this is a minor, that is not an adult, and this minor will have to go to a certain location in the U.S. and give evidence on a televised system. But because of the age of this witness, the guardian will have to accompany him. But in that particular case, the guardian refused to cooperate. And because they were able to prove that they have made all reasonable steps and efforts so that the guardian who was in the U.S. to bring the underage witness to in front of the televised system. It's not that the declarant or the witness himself was not willing. So in a reasonable situation where the best efforts or reasonable steps have been made, but it's not reasonable, practicable, that would be a situation that was admitted by the court. And for the New Zealand situation, I will not repeat anything here. And we have already provided response to the legal advisor in one of the appendices. We have summarized some of these case laws. So going back to Mr. Charles' question, this is completely reasonable in his concern concerning the necessity conditions, in particular conditions 3 and condition 4. The way we approach it is not that it can be so flippant. You know, the declarant cannot say that I'm not willing, I don't want to. That would not be admissible. And it is not like some very easy steps are taken and claim that all reasonable steps have been taken and the declarant cannot be found. That's condition 4. Now, that would not be admissible either. And also, further, I have responded to Mr. Ho's question just now, and that is, for the necessity condition, in particular for the prosecution, the requirement for that has to be beyond reasonable doubt. It will have to satisfy that burden of proof, which is quite stringent. So, and this is in keeping with the requirement for the prosecution for criminal law as practiced in Hong Kong. And also, as mentioned, this is but one necessity condition. There will have to be other conditions as well. The reliability threshold is one, for instance. And if you look at 55R section, these are but 2 among 5 conditions, and there are the other 3 conditions as well. Satisfying the 55R conditions, you only satisfy the condition that the court can admit such evidence. But how much weight does the court attach to the evidence is something different. So this is just the beginning. So how much weight you attach, the court attaches to the evidence is another matter altogether. But because this is a hearsay evidence, the declarant is not receiving cross-examination in court. Therefore, we want to provide certain balanced safeguards. For example, the defendant, for example, the hearsay evidence giver is adduced by the prosecutor, even though the witness is not in court, but the credibility or the reliability of the hearsay evidence can be challenged. So it is about credibility of evidence given by this particular witness. Even though the court had admitted the hearsay evidence, but there can be challenge to the evidence's reliability and credibility, or even there can be challenges for conflicts of the evidence given. So we understand Mr. Chow's concern, and yes, there are a lot of safeguards. We understand. Right. So there is a key term, that is balance. in this meeting. We have heard that. Now, because of time, we cannot extend this meeting any further. There are other meetings, and so we will leave this to the next meeting. The next meeting, in terms of date, I am fixing this to Wednesday, 29th of July, 2:30 in the afternoon. There will be notification from the Secretariat to members, and if the DOJ can prepare the supplemental information and papers, please do that before the meeting. End of meeting if there's no AOB. Thank you.